I, Dr. Kavita Singh, Associate Professor of Law, working in WNBNUJS for last 15 years, would like to present before you a paper on the topic hurt and grievous hurt. So, Winston Churchill 1942, after the World War II, said, now it is not the end, it is not even the beginning of the end, but is perhaps the end of the beginning. Nowadays, magistrates, courts are flooded with cases of hurt and grievous hurt. Offences are dealt under the chapter titled of hurt. Section 319 to 338 gives definition of simple hurt, grievous hurt and aggravated forms of hurt with punishments. For voluntary causing hurt, grievous hurt, aggravated forms of hurt and other aggravated forms of hurt. This module gives an overview of the law relating to hurt and grievous hurt. The objective of this module is to inculcate with the reader in-depth knowledge of law relating to hurt, grievous hurt and aggravated forms of grievous hurt with the help of relevant case laws and illustrations to explain most basic of concepts required for better understanding of this module, to provide for answers to important issues related to hurt and grievous hurt. Offences of hurt and grievous hurt under the Indian Penal Code 1860 understand the section 319 to 338 dealing with the causing of hurt and grievous hurt and the punishment thereof. Section 319 defines hurt as whoever causes bodily pain, disease or infirmity to any person is said to cause hurt. Section 325 defines voluntary causing hurt as whoever does any act with intention of thereby causing hurt to any person or with knowledge that he is likely thereby to cause hurt to any person and does thereby cause hurt to any person is said voluntary causing hurt. Section 323 lays punishment for voluntary causing hurt as whoever except in the case provided for by section 334 voluntary causes hurt shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine which may extend to 1000 rupees or both. Dragging women out of house held an offence of hurt. Causing of pain being sufficient to constitute hurt, it is not necessary that there should be visible injury caused on the person and victim, not it is necessary that injury should be received by physical contact. Causing pain by voluntary act is sufficient. A person who deliberately sets out to cause shock with a person weak heart and succeeds in doing so cause hurt to that person. The term infirmity has been interpreted to mean inability of an organ to perform normal functions which may be either temporary or permanent. Intention or knowledge, the gist of the offence under this section is the intention or knowledge causing the hurt voluntarily. There cannot be a voluntary causing of hurt unless there is intention of causing hurt or hurt is likely to be caused by the act. As such, a rash or a negligent act which causes hurt does not come within the ambit of this section. In Re Marana Gaudan case, the deceased owed one anna to the accused and demanded the same from the deceased. The deceased told him that he had no money and would pay him later. On hearing this, accused kicked the deceased twice in the stomach. The deceased collapsed and died due to shock. It was held that accused could not have had the intention to cause death or the knowledge of his act of kicking in the abdomen will cause his death. Hence, he was convicted under section 323 for causing simple hurt. Element of the offences are accused voluntarily caused bodily pain, deceased or infirmity to the victim. The accused did so with intention of accused of causing hurt or with the knowledge that he would thereby cause hurt to the victim. Grievous hurt Section 320 states specifically the nature of injuries that can be categorized as grievous hurt. No other hurt outside the category of injuries enumerated in section 320 can be termed as grievous hurt. Unless there is hurt caused comes within the injury specified in the section 320, this section will not apply. Grievous hurt, the following kinds of hurts only are designated as grievous. First, emasculation. Secondly, permanent privitation of sight and either eye of either eye. Thirdly, permanent privatization of hearing of either ear. Fourthly, privatization of member of joint. Fifthly, destruction of permanent impairing of the power of any member or joint. Sixthly, permanent disfiguration of the head or face. Seventhly, fracture or dislocation of bone or tooth. Eighthly, any hurt which endangers life or which causes the sufferer to be during the space of 20 days is severe bodily pain or unable to follow his ordinary pursuit. Section 323 provides punishment for voluntarily causing hurt as whoever except in the case provided by section 334 voluntary causes hurt shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine which may be extended to 1000 rupees or with both. Section 325 punishment for voluntarily causing grievous hurt. Whoever except in the case provided by the section 335 voluntary causes grievous hurt shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. The offence of grievous hurt which causes severe bodily pain applies only when such effect lasts for a period of 20 days and not when the victim dies before the expiry of the period due to tetanus infection. It was held that this case was not fit for grievous hurt. Section 322 states what amounts to voluntary causing grievous hurt, and 325 lays down punishment for voluntary causing grievous hurt. Fraction or delocation. Supreme Court in Hiralal versus State of UP held that it is not necessary that the bone should not be cut through the through or crack must intend from the outer or to inner surface of that there should be displacement of any fragment of the bone. If there is a break by cutting or splintering or the bone, or there is a rupture or fissure in it, it would amount to fracture under section 320 clause 7 of Indian Penal Code. Hurt endangering life. The dividing lines between culpable homicide and grievous hurt are very thin. In former case, the injury must be such as they are likely to cause death, and in latter they may endanger life. Blow in the head with an axe which penetrated half an inch into the head is an act which is likely to endanger the life and is covered under clause 8 of section 320. Accused in this case convicted under section 326. Medical opinion on nature of hurt. The opinion of the doctor about the nature of injury is not binding on the court. Medical evidence can hardly be relied upon to falsify the evidence of eyewitness because of the fact that medical evidence is guided by various factors based on guess and certain calculations. The prosecution is not bound to explain the superficial injuries on the person of the accused not caused at the time of the occurrence. Factors for consideration under grievous hurt. There are certain factors which are required to be taken into consideration before awarding appropriate sentence to the accused. These factors are only illustrative in character and not exhaustive. Each case has to be seen from its special perspective. The relevant factors are number 1, motive or previous enmity. whether the incident had taken place or spur of the moment. Thirdly, the intention, knowledge of the accused while inflicting the blow or injury. Fifthly, whether the death ensured instantaneously or victim died after several days. Sixthly, the gravity, dimensions and natures of injury. Seventhly, the age of the general health condition of accused, whether the injury was caused without premeditation in a sudden fight, the nature and the size of weapon used for inflicting the injury, the essential ingredients for punishment of the offence under section 325 voluntary causing grievous hurt are: number 1, accused voluntarily caused hurt. Hurt was grievous hurt within the meaning of the section 320. Section 324, voluntary causing hurt by dangerous weapons or means. Whoever except in the case provide for by section 334 voluntarily causes hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which is used as weapon of offence, is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Section 326, voluntary causing grievous hurt by dangerous weapon or means. Whoever, except in the case provided by section 335, voluntarily causes grievous hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which is used as a weapon of offence, is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by any means, animals shall be punished with imprisonment for life, or with imprisonment of any description for a term which may extend to 10 years, and shall also be liable to fine. Section 327, voluntarily causing hurt to extort property or constrain into illegal acts. Whoever voluntarily causing hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any property or valuable security, or of constraining any sufferer or any person interested in such sufferer to do anything which is illegal or which may facilitate the commission of an offence, shall be punished with imprisonment of either description of a term which may extend to 10 years, and shall also be liable to fine. 326, voluntary causing grievous hurt by use of acid. This is a new addition. Whoever causes permanent or partial damage or deformity to bumps or limbs, or disfigure or disables any part of the body of a person, or causes grievous hurt by throwing acid on or being administering acid to that person, or by using any other means with the intention of causing or with the knowledge that it is likely to cause such injury or hurt, shall be punished with imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life, and with fine. Proviso added to this is that such a fine shall be just reasonable to meet the medical expenses of the treatment of the victim. provide further that any fine imposed under this section shall be paid to the victim. Section 326B, voluntarily causing or attempting to throw acid, is a new addition by Criminal Law Amendment Act 2013. Whoever throws or attempts to throw acid on any person, or attempts to administer acid to any person, or attempts to use by any other means with the intention of causing permanent or partial damage or deformity or burn or maiming or disfiguring or disability or grievous hurt to that person shall be punished with imprisonment from 5 to 6 years and fine. Now coming to causing hurt or grievous hurt on provocation, where simple hurt is committed with dangerous weapon, then section 324 will apply. Where grievous hurt is caused by dangerous weapon as defined in section 320, then section 326 will apply. In order to sustain conviction under section 324, prosecution must prove that the accused voluntarily caused hurt and that such hurt was caused by means of dangerous weapon. Nothing short of that would suffice. Lathi, bamboo sticks had not been a dangerous weapon depending upon the size, thickness, etc. In Anwarul Haq versus State, it was held that any instrument used as a weapon of offence is likely to cause death, means dangerous weapon, which is used by the accused, which is likely to cause death. Now coming to dangerous weapon or dangerous means. In case of Mahendra versus State of MP, it was held that accused must commit an act with the knowledge that thereby he was likely to cause hurt or grievous hurt to the victim. It was caused by any shooting instrument, or by any stabbing instrument, or by any cutting instrument, or by any instrument if used as a weapon of offence likely to cause death, or by a means of poison, or by means of any explosives substance, or by means of any corrosive substance, or by means of any animal. Acid attacks are an increasing phenomena in India. Section 326A of IPC, which deals with causing grievous hurt by throwing of corrosive substance, etc., was insufficient, inadequate to deal with the issue. Firstly, the definition of grievous hurt is not broad enough to cover the various kinds of injuries which are inflicted during acid attacks. Secondly, the section does not cover the act of administering acid. Thirdly, the section gives a wide discretion to the court as far as punishment is concerned. The cases on acid attack in India shows that normally inadequate punishment is awarded in these cases. The section in the IPC does not punish the intentional acts of throwing acid if no injuries occurs. Lastly, the section also does not specify whom the fine should be awarded. To the inclusion of acid attack as specific offence in Indian Penal Code and the law for compensation of victims of crime is a step towards giving justice to victims of acid attack. The Lakshmi writ petition case states that compensation to victims of acid is of vital importance as huge medical costs are often involved. The victims of acid attack need both short term as well as long term specialized medical treatment and plastic surgeries. The provision in Indian law for giving compensation to the victims are insufficient. The writ petition therefore prays that an amendment be made in the Indian Penal Code, Indian Evidence Act and Criminal Procedure Code for dealing with acid attack as a special offence. Guidelines be framed and an act be passed to attend to the needs of all the acid attack victims in India. A committee be constituted and appointed for adopting measures for the proper treatment, aftercare and rehabilitation of the victims of acid attack. That acid attack in all forms be made a scheduled banned chemical which is not readily available over the counters. Presumption as to acid attack: if a person has thrown acid on or administered acid to another person, the court shall presume that such an act has been done with the intention of causing or with the knowledge that such act is likely to cause such hurt or injury as is mentioned in section 326 capital A of Indian Penal Code. The pictures show the primary reason and responsibility of acid attack in and around the nation. It can be clearly observed that the love and sex rejection along with rejection of marriage proposals are seen as a major reasons behind the horrendous crime. Extortion of property or to constrain illegal act: when accused voluntarily cause hurt or grievous hurt to the victim to extort property or compel illegal act, section 327 and section 329 applies. The essentials of these offences are accused voluntarily caused hurt or grievous hurt to the victim, victim died for this purpose, extortion from the victim or any person interested in victim, any property or valuable security compelling the sufferer to do an illegal act, facilitating the commission of the offence. The aim of this section, which is the injury is caused and not the nature of the injury, punishment is imprisonment for life or imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Administering poison: a poison is administered when it is left by the accused to be consumed by the victim. Offence is not considered as administered unless it reaches victim's stomach. Compounder was found guilty of administering deleterious substance to his own doctor, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Essential elements of this offence are as: accused administered poison with intention of causing hurt, with knowledge that it is likely to cause hurt, and to facilitate the commission of an offence, it is also provided that the accused was responsible in distributing this attack to the arrack shop near the railway station and thereby caused poison attack to be taken by the consumers, and in that way people who consumed died as a result of poisoning. Therefore, the accused has been rightly found guilty of the offence punishable under section 327 and 328 of IPC. The section 55 and 55N of the Abgari Act, section 330 of Indian Penal Code punishes the public servant in custody whose custody any person is tortured while interrogation, investigation with imprisonment of either description for a term which may extend to 7 years shall also be liable to fine. Torture resulting in grievous hurt, injury invites punishment up to life and which may extend to 10 years with fine. Torturing, if the person in custody dies, custodial death takes place, and then in that case the public servant can be sentenced to death, punishment or imprisonment of life not less than 10 years of either description or liable to fine. When a public servant keeps in his custody any person wrongfully to escort confession, evidence relating to the case in the stage of investigation shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. In Emperor versus Miran Baksh, a police head constable had his juniors tortured a suspect in custody to death. The head constable then tampered with the records and disposed of the body to hide the facts of the death. The trial court acquitted him and the state appealed the acquittal. The Lahore High Court held that though the death was undoubtedly because of the torture, the police officers could not have intended to kill as they were inebriate at that time. The High Court concluded that the only intention attributable to them was the voluntary causing hurt. The head constable was convicted under section 331 of the Indian Penal Code and sentenced to 10 years rigorous imprisonment, and the junior officers were convicted of abatement of the offence and was sentenced to 5 years imprisonment. Conviction under this section 331 of Indian Penal Code for torture to extort a promise of restoration of a woman that the prisoner was said to have abducted. The trial court found that the accused guilty of committing torture, but High Court ruled that the accused were not extorting confession, but were merely seeking a promise, and terms of section 331 of Indian Penal Code were not met. The purposeless differences between committing torture for seeking a promise and committing torture for seeking a confession has created a loophole in the law. Section 348 of the Indian Penal Code deals with any servant wrongfully confines any person in his custody to extort confession or compel restoration of property shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. In Emperor versus Sanjeev Ratnappa, court convicted accused policemen under section 330 and 348 of Indian Penal Code for torturing accused to extort confession. Supreme Court held that the punishment provided under section 330 is inadequate to repair the loss done to the victim, and the victims of crime should be compensated. Causing hurt to or grievous hurt to debtor public servant, section 332 and 333 talks about this. Essential ingredients of the offence under 332 and 333, firstly, accused voluntarily caused or hurt or grievous hurt to a public servant. It was caused while the public servant was discharging his duty. Hurt or grievous hurt was caused to prevent the or deter him from discharging his duty as a public servant, or such hurt or grievous hurt was in consequence of having done or attempted to be done any in the unlawful discharge of his duty as a public servant. The term public servant is defined under section 21 of the Indian Penal Code. These sections apply only when public servant was discharging public duty, and it has to be proved that it was intentionally act of the accused to deter public servant from performing his duty. Causing hurt or grievous hurt or provocation, section 334 to 335 deals with it. The ingredients of this offence: the accused voluntarily caused hurt or grievous hurt, it was caused by grave and sudden provocation. The accused neither intended nor did he have knowledge that it was likely to cause hurt or grievous hurt to any person other than the person who gave the provocation. If the injury caused is simple hurt, then the punishment under section 334 is imprisonment of either description, which may extend to 1 month, or with fine which may extend to ₹500 or with both. If the injury caused is grievous hurt, then the punishment under section 335 is imprisonment of either description, which may extend to 4 years, or with fine which may extend to ₹2,000, or with both. It is important to establish that there was provocation, and such provocation was grave and sudden. Test of grave and sudden provocation is whether a reasonable man belonging to the same society as the accused would be provoked or not. Causing hurt or grievous hurt by endangering life or personal safety of the others. Section 336, 337 and 338 deals with this. If any act done rash and negligent manner to endanger human life or the personal safety of others it will be an offence under section 336. Section 337 and 338 makes the causing of simple hurt and grievous hurt respectively an act endangering life or personal safety an offence. The essential ingredients of the case as follows: the act of the accused must have resulted in simple or grievous hurt, the act must be done in rash and negligent manner, the rashness or negligence must be to the extent of endangering human life or personal safety of the others. Such an offence is punishable with imprisonment of either description for a term which may extend to 3 months, or with fine which may extend to 250, or with both. Coming to conclude the module, to some extent the law relating to hurt and grievous hurt is very comprehensive and the punishments are more or less balanced. The Criminal Law Amendment Act 2013 is a recommendable step or effort of the Parliament to make an acid attack an attempt to make an acid attack punishable. Only the Prevention of Torture Bill introduced by the Prime Minister in 2010 to make torture punishable offence could not be passed. Statement of object and the reasons of the bill stated that bill was being introduced to ratify the UN Convention Against Torture of 1975. India is signatory of the convention, but has not ratified it, and was burdened to enact a new law for it. The bill defines torture and prescribes condition under which torture is punishable. The Prevention of Torture Bill 2010 seeks to provide for punishment for torture committed by government officials. The bill defines torture as grievous hurt or danger to life, limb and health. Complainant against torture have to be made within 6 months. The sanction of the appropriate government is required before a court can entertain complaint. The act did not see the light of the day, but if we already have the law in place, then the chapter on hurt and grievous hurt would be complete. Thank you.